Good morning, afternoon, or evening. I am Stephanie Joy with All Things Social Security and the attorney at Joy Disability. You're about to see what should be a question and answer format type of chat from our live session on a particular topic that we find that a lot of people keep asking about. So I'm sharing it here. If there are pieces that could have been added that weren't added during the live, because it's a kind of a fast-paced Q&A that we do every Wednesday at 1 p.m. You might just find that I added something to the end of it to give it a little more clarity and a little more details for those that are interested in that particular topic. So check to see if that's at the end. Otherwise, enjoy the video. Bye-bye.
My DLI is 2023. Does the 5-year rule apply to me? Well, yes. It applies starting December 31st, 2023 and going back to probably, this might be the good news, because you worked most of 2018. That year you earned all your credits, even though you didn't work till the end of the year. This is kind of important. I think I did a video on this because it came up with one of my hearings this year. When you go 5 years back to from December 31st, 2023, the end of that 5 years, I believe, is January 1st, 2019. So you got all of 2019, 2020, 21, 22, 2023. That's 5 years. This is where it can benefit you, Baxter. You stopped working 4 months or 3 months, probably almost 4 months earlier than your look back 5 years. So now they can never say you have unskilled work, and this will depend on if you're with grids. It's not going to really affect younger people, but you have no work, no past relevant work. So they can't say, can he do his prior job? They can't look at that September 3rd job and say, could he do this job? If he can, he loses at step 4, and you never really get to go on to step 5. If they say there is no past relevant work, you pass step 4, and now you just have to prove you can't do all the other jobs. And if you're gridding, that's super important because that's one of the grids. Can you do your old job? It's actually two grids, two prongs of the grid. You can't do your old job because you didn't have one in the relevant time period that you have to. This is if you're over 50, and then you just have to meet prong 1. Christina's in the house. Hello from California. Hello to you too, Christina. I hope you're doing okay. Shannon says, I'm at federal level with my first application. I'm going to get a water gun, and I'm going to shoot this dog. I should have brought it in here. Whining out the door. That's the Bernese. I want to wring her neck. I'm at a federal level. Maya, no. I'm at federal level with my first application, and now at ALJ with my second application. Okay. So you appealed your first application that got denied at ALJ and Appeals Council. And that's often federal district court, totally separate. And then she has a new second application, and it's at the ALJ with that one. I guess we're gonna have to do them separately. If your federal level one resolved before you had your hearing, they would merge. But looks like it depends when your hearing is going to be. They will merge it if you haven't had it yet, and then he will be deciding the whole kit and caboodle at each point, because you could win it. Sounds like you still had a DLI left over after your last case went down, which is great. And so you could do another filing. So he could find that the old one, yes, indeed, that I made a mistake, or you probably have a new judge now, actually. Made a mistake. There was enough evidence back then. This is just done wrong here. And she gets all the way back to then, which means, and they always have to find out that you're still disabled to this day. So you always have to keep your medicine, your medicals going while you're waiting for hearing. And of course, to some degree after you prevail for your next CDR.
Good morning. An update on the rule change that changes past relevant work from 15-year look back period to 5 years. I've said this before in prior videos when we got the rumor of it back in the fall, when we got the announcement that it was going to be taking place in June a couple of months ago. Biggest, best improvement I've seen in my tenure doing Social Security disability work. In my opinion. I'm sure maybe other professionals think other things are more important. I think this one's really fabulous. in any event, just as a refresher, past relevant work is something that you have to prove that you cannot do. So the definition of past relevant work is very important. Remember, past relevant work isn't just your most recent job that you could no longer do and provably could no longer do due to disability impairment, medical impairments. You have to prove you can't do your other past relevant work also. So the definition of past relevant work is critical. And one of the criteria to be past relevant work that could be held against you is that it occurs in a certain time frame in the past, recently enough. It's a recency test, but the recency number was 15 years backwards. That's a long time. So this change from 15 years to 5 years is incredible. Think of it this way. 15 years ago, you may have been doing a very simple, non-arduous job. And you later on, as you gain more skill, gain more education, whatever it is, gain more experience, you take on additional responsibilities. It might be more arduous physical responsibilities. It may be higher mental skills. Either way, what you were booted out of due to your medical impairments is probably a far more complicated job than what you used to have. So while you can prove that you can't do your most recent job that was complicated or arduous, does not mean you can't do the one before that, or 13 years ago, 15 years ago. So now the 5-year rule will mean they can only look prior to the 5 years prior to, like if you're applying, the 5 years prior to the date you allege you're disabled. 5 years. This is such a magnitude to me. It's incredible. Okay. The question remains, aside from the fact that instead of it being effective June 8th, it will be effective June 22nd. Okay, so it's a little difference. It might affect some people, but hopefully not too many. And the other question was, but what does it actually mean? Like, who is it going to apply to? Is it going to apply to only people who apply after June 22nd? Or will it apply to people who applied before but haven't received a decision, not a first decision, not a second decision, not an ALJ decision? So I want to give you the language that I just received today. I think this will be officially published tomorrow, perhaps. It says, we will apply the final rule, that's the 5-year rule now, and all procedures set forth therein as previously described in the original published final rule, which was, I believe, in April, to all claims newly filed and pending. I think that's what some people wanted to hear, beginning on June 22nd, 2024. So if you have a pending claim, and I will give a shout out to Bill. Bill, a client of mine, was concerned about this as we were recently filing. I said I didn't think you have to worry about it, but we will cross that bridge when we get to it. You'll be happy to know. So yeah, pending claims get the benefit of the rule. If your claim is decided by an ALJ, this is my theory here, an ALJ decision dated before June 22nd, I think you're out of luck. Now, hopefully you still defeat all the past relevant work regardless, but I believe you'd have to follow the 15-year rule based on this. And this is not the full synopsis here, but I will link it to you because it is the Federal Registry. So, register, I should say. By the way, it's volume 89, number 109, Wednesday, June 5th, rules and regulations. All right, so that is awesome. It is quite a great relief, I would say, particularly for the over 50 crowd. Less so for the under 50 crowd. I'm sorry, guys, you're always getting the shaft, but there are reasons for that. They kind of do make sense as much as they pain us. In theory, it shouldn't hurt a disabled person under 50, but we know how difficult and onerous that burden is. So I am going to, I think I'll just attach here, if I can find it, the original video But know that this is the final result. So if you don't need that, don't worry about it. I will talk to you later, guys. Have a great day. Very happy to hear this. Bye-bye now. Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Hey guys, I have huge news. It came out just maybe 30 seconds ago to me. Got it in an email from my source, one of the major two organizations that report to us on Social Security and work really hard legislatively to get things accomplished and through the agency itself. Not too many months ago, I put out a video on the proposed rule change for past relevant work and what the SSA can consider when determining whether you, in fact, can do your past relevant work. There is a recency rule, and forever and a day, it has been 15 years. It's always been that. I've been doing this 2 decades, and it was 15 years, and it's still 15 years. However, they decided they wanted to change it to 5 years. This is so huge. I'm going to attach the video where we talk about why it's huge, so I don't repeat myself too much. But guys, this is the first big claimant-friendly, immense claimant-friendly rule change in my lifetime with this. I know during 15 and that whole era, they were creating rules that were really going to be harder for disability claimants, as well as for some retirees. And they succeeded in doing that, and a lot of things became effective immediately, and some in 2017 as a result. But this one is the pro-claimant, really getting a grip and understanding on the fact that a job that you could do, that you did 14 years ago, and you could probably do it now, is no longer going to sink your ship at step 4. So huge. Looking back 5 years, it's going to be really your recent work. 14 years ago is not really recent, right? In terms of how we remember we did it. Are the conditions still the same? Are the technologies still the same? The processes, all that kind of stuff, the expectations of output, etc. So they've recognized and they are acting upon the fact that things have changed. And the rate at which probably jobs change and what's needed for a job, the rate at which they change can no longer be contained in a 15-year period. It is much quicker that things change. So anyway, this is huge. And we don't have to wait for 6 months for this to take effect either. It's taking effect June 8th. So what I don't know is, will it be affecting cases that get decided June 8th or after? Or will it be affecting cases that get filed June 8th or after? The final rule is going to be published tomorrow. Once again, we have a little early insight into it, which I really always appreciate. And when I find out that date, I will make sure that I post it in the comments or to the membership. If you're not a member, consider joining. And, it'll let you know what kind of impact this will have if you have a current case, or certainly if you have a future case. It is momentous. It is huge. All right, guys, that's it. I'm going to attach the actual further explanation, which I did a few months ago, and I got wind that this was going to potentially be coming down the pike, and I reported it to you. And take a listen. I'll talk to you later. Bye.